Okay, we are all set to go. Certainly.
Corey,
Morning. Can you state your name?
Corey D.
All right. Do you have a middle name, sir?
Yeah, Corey Jason D.
Okay, thank you. Again, those two allegations, felony allegations, dangerous drug possession or use, drug paraphernalia possession or use. The two misdemeanor violations are consuming alcohol in a vehicle and open container of alcohol in a vehicle. On those charges, you have the right to remain silent, right to counsel, and right to trial. Regarding the felony allegations, I've scheduled you for a preliminary hearing on the 11th of May. That'll be at 4 o'clock p.m. The preliminary hearing is to determine if there's probable cause to charge you with those two felony allegations, not convict you. If probable cause is found, your case will bind over to the Gila County Superior Court. There is a possibility that the case would go in front of a grand jury prior to that date. Best thing for you to do is to call a business day before that court date to see if it's still proceeding. But as of now, you're ordered to be there. Do you understand that?
Yes.
All right. Regarding the misdemeanor allegations, I've scheduled you for an arraignment on those two allegations on the 27th of May. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to those misdemeanor allegations. Depending on how you plead will be what happens next with those court proceedings, and all of those options, as well as the penalty range, will be explained to you prior to you giving your plea. That hearing is scheduled for 9 o'clock in the morning on the 27th. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately of any change of address or if you obtain a physical address. Do not leave the state of Arizona without permission of the court. Do not possess or consume any alcohol or drugs without a valid prescription, and because of the felony allegations, not to possess any firearms. And if you're convicted, you could become a prohibited possessor. On the two felony allegations only, I'm placing a $1,000 bond hold on you, so you'll remain in custody. On the two misdemeanor violations, I'm releasing you on your own recognizance. Being that you're held in custody on felony allegations, you have the right to a court-appointed attorney if you cannot afford to hire one. So I'll be sending you a financial questionnaire that, if you wish to exercise your right for a court-appointed attorney at little or no cost, complete that financial questionnaire. The other thing that happens since you're in custody on the felony allegations is the prosecutor, the attorney for the state of Arizona, must file a complaint against you within 48 hours, business hours, not counting weekends and holidays. If they do not file a complaint within 48 hours, then you'll be released on your own recognizance and no bond will have to be posted. If they do file the complaint and you qualify for the court-appointed attorney financially, the attorney will be assigned at that point. Do you understand that, sir?
Yes.
Do you have any questions about anything that we've discussed?
How would I get a phone call to see if I can post bond?
Okay, they talk to the detention staff, and as soon as they have a moment to be able to allow you to use the phone call, then they'll afford that to you to be able to make arrangements for that.
All right.
Any other questions?
No, Your Honor.
Okay, that's all I've got for you.
Thank you.
Your Honor,
Yes,
did we say something?
hang on one second. Hello, can you state your name, please?
Harold Andrew Tyson.
All right, Mr. Tyson. Excuse me one second. Sorry, the charge is aggravated assault by impeding breathing. That's a felony allegation. And then 3 counts of misconduct involving weapons, all the same charge. Just 3 different counts on those charges. You have the right to remain silent, right to counsel, and right to trial. You're scheduled for a preliminary hearing on the 11th of this month at 4:00 p.m. The preliminary hearing is to determine if there is probable cause to charge you with those felony allegations. If there is probable cause, then the case will bind over to the Gila County Superior Court. It is possible that the case could go in front of a grand jury to make that probable cause determination. If that occurs, you'll be notified that you do not need to appear on this court date. Best thing to do is to check a business day ahead of time to see if it's still proceeding. Okay?
Understood.
Your release conditions are obey all orders of the court, do not commit any crimes, notify the court immediately if you obtain an address, not to leave the state of Arizona without permission of the court, no contact with the alleged victim in any manner, not to go near the location of the alleged offense, and not to possess any firearms. Do you understand those release conditions?
Understood.
Okay, there's a $20,000 bond posted, requested by the state that will remain in place. Being that you're held in custody on this, you have the right to a court-appointed attorney at little or no cost to you. If you wish to exercise that right, I'm going to send a financial questionnaire with your paperwork, so complete that paperwork, and if you qualify, then the attorney will be assigned to that and be made aware of your in custody status, be made aware of your charges and your bond. You understand?
Yes, sir.
Do you have any questions for me at all?
Well, in April, the beginning of April, I was supposed to be going to court anyways on this, and I called the courthouse, and they said there was an active warrant for me. So I willingly came over to the sheriff's and tried to turn myself in, but I guess it got signed today. So I'm like, I'm not a flight risk. So maybe if I'm asking for, you could maybe lower my bond a little bit, or so I can do half collateral, half cash. So I'd like
Okay.
to be able to fight these allegations from not in custody. It looks a lot better, and I'm not a flight risk. Like I said, I was willing. I even turned myself in, but I guess it hadn't been signed at the time. And I
Correct.
got a certified mail the other day stating that I had court on the 18th, which I was planning to come for anyways for this.
Yeah, and sir, I believe everything you said right there. Matter of fact, that information that you gave to me, I was briefed with by the sheriff's office and the jail staff, so I have no reason to doubt any of that you said. The reason why the bond is in place, it's because of the incident itself that took place. I don't need to go into the merits of that, and I don't want you to self-incriminate. That's why the bond is, and you're exactly right. The charges hadn't been filed yet. The complaint wasn't filed yet. Now it is. So when you were checking, it just hadn't been processed yet. So here we are with it. The $20,000 was what originally was placed on you. It was the same amount as what they requested, so that's why it's still in place. If I released you, it would alleviate your ability to have an attorney appointed to the case, at least at this point, because you would not be held in custody. So I'm not saying I'm keeping you in custody to give you the ability to have the attorney, but if I did release you on your own recognizance, that would go away, at least for now, it would. So
I'm okay with that. Like I said, like I was in the process of moving, finding like if I'm gonna come to court. There's no reason for me not to. I'm a man.
well,
I'll stand for.
so
But
so the date is 10 days from now.
yeah,
This has to stay in place for them. Then what will happen is one of two things. If there is at the preliminary hearing, if there's probable cause, then that all shifts over to the Superior Court. They'll be made aware of the information that you just provided me, and also make sure that you speak to it again to when that judge gets it or receives it at that point. That
all right.
you checked yourself in, it wasn't filed yet, and it shows your willingness. At this point, this is what I originally had placed on it in the beginning, and that you were released because it didn't file, and then when it did file, it's back on and at the request of the prosecutor. So it's going to have to remain in place for now, but certainly I'm giving you I believe you with what you're saying. I was briefed on it with what you're saying. It's just it really needs to remain in place at this point of the case. It could go away in its entirety when it gets in front of the Superior Court, if it in fact does, if there's probable cause found. If that preliminary hearing does take place and it's in front of me, we will absolutely revisit these release conditions on that hearing date.
All right.
Okay. Anything else, sir?
No, thank you, sir.
Okay, you're welcome.
Thank you, Judge.
You bet. And I'll send it shortly.
Okay, thanks.
Give me 1 minute, ma'am, and I'll speak to you regarding your questions.